Only waiting now on Mr. Ken Gibson. Well, there we go. Good morning.
Hello, this is Ken Gibson.
Fantastic. Good morning and welcome to all three of you. This is Roxana Gamusio. I'm the new executive director with this program. We have here Mr. Collins in person, so we have a quorum, and the attorney for the board is here, so we're getting ready to start recording. If you'll give us just a couple of minutes, we'll get started.
Thank you, ma'am.
Thank you.
Thank you. Good morning, everybody.
Good morning.
Good morning.
Awful lonely here. I look ridiculous sitting up here by myself.
Thanks for getting out in the cold.
I live for this.
We're not recording yet.
And I meant to tell you we've got cream and sugar over here.
As is, thank you.
We are live? Okay.
Brad, are we ready to go?
All right, so we are live. I will go ahead and turn it over to Mr. Collins.
Okay. Did we just lose somebody?
Oh, you did. Yeah, that's perfect. We're good. We've got all four board members on and one person here, so we can get started.
Okay. I'll call this regularly scheduled meeting of the Tennessee Board of Court Reporting to order. Ask the executive director to do a roll call, please.
Thank you. And this is Roxana Gamusio, the executive director with the program. Mr. Brighton Collins. Britton. I apologize.
Just like the country.
You got it. Present.
Present.
Ken Gibson.
Present.
Chancellor John Rambo.
By phone.
Thank you. And Earl Houston.
By phone.
Okay, and we have absent Ken Mansfield and Terry Beckham, but so we have a quorum to proceed.
Okay, I will now read into the record the statement of necessity with respect to the telephone conference. According to TA 8-44-108B2, if a physical quorum is not present at the location of a meeting of a governing body, the governing body must file such determination of necessity, including the recitation of facts and circumstances on which it was based, with the Office of the Secretary of State no later than 2 working days after the meeting. Furthermore, TCA 8-44-108A3 defines necessity as matters to be considered by the governing body at that meeting require timely action by the body, that physical presence by a quorum of the members is not practical within the period of time requiring action, and that participation by a quorum of the members by electronic or other means of communication is necessary. This is the regularly scheduled meeting for the Tennessee Board of Court Reporting. The purpose of today's meeting, with some members attending by teleconference, is to discuss the agenda as noticed on the website earlier. This regularly scheduled commission meeting is taking place in room 1B of the Davy Crockett Tower, 500 James Robertson Parkway, Nashville, Tennessee. Notice of this meeting was posted on the court reporter's website on December 6th of 2016. All right. This time, we'll do a review of the agenda from last meeting, which was held on June the 16th of 2016. Does everybody have an opportunity to review the minutes?
Yes.
Okay. Rather than reading the minutes, it's all been distributed to you before. Does anybody have any issues with the minutes?
Mr. Collins, this is Ken Gibson. I just had one clarification.
Okay.
In the minutes, it makes reference to a comment regarding contracts. And it was your comment, and I just wanted a clarification. It says, Mr. Collins felt that the board should avoid involving itself in regulating contracts. And my only question is, were you referring to third-party contracting with insurance companies, or were you referring to contracts in general, any kind of contract?
If I recall correctly, of course this was 4 or 5 months ago, that was taking place. We were in the rulemaking hearing, and at that point I think we were discussing some of the proposed changes to the ethical standards And there'd been some discussion about modifying those rules as they relate to, I think what y'all would call third-party contracts, which is, the contracts that people are having with their insurance companies and such, these kind of mass court reporting agreements. And that's obviously been a hot-button issue before the board for the last year or two. So my recollection is that comment related was within the context of that discussion.
Okay, thank you, and I appreciate that. I just want to set that, because of the third-party contracting issue, I think if we could refer to that, to contracts when we're referring to something in general, like a contract between a consumer and a court reporter or two court reporters, so that if we're referring to actual contracting with third parties, insurance companies, that we actually use that terminology. That's just a suggestion for clarification. I don't know if you want to change the minutes because of that or not. It doesn't matter. I just want to make sure we're clear.
I think it'll be easy enough for us to add, and the board can still proceed with motioning to accept these as amended, and then the office will add that piece to clarify that we're talking about third-party contracts.
Okay, we need a motion to that effect, I assume.
Chancellor Rambo, I make the motion suggested.
If we may, there's also a question also about a separate part of the minutes here. Actually, the next sentence, it refers to Judge Rambo suggesting additional rules relating to transcripts that would limit education credit, to courses specific to court reporting. Frankly, that sentence confuses me. The additional rules relating to transcripts that would limit education credit to courses specific to court reporting. My recollection of that part of the conversation in the rulemaking hearing was that there were a lot of extraneous activities that were getting approved for CE credit, and Chancellor Rambo's suggestion was that if we were going to have CE credits given for something, that it needed to relate directly to court reporting, and I'm confused about what it means here when it says additional rules relating to transcripts that would limit education credit.
Well, that's what that sentence is supposed to say. I could rephrase.
Okay.
So the motion as it stands is with the amendments for those two comments. We could proceed if the board's comfortable with it. Otherwise, we wouldn't be able to approve it till the following meeting.
Sure. Okay, Chancellor Rambo, you made such a motion?
I have.
Is there a second?
Second, this is Ken Gibson.
Okay, would the executive director call a roll?
Absolutely. Vice Chair Britton Collins.
4.
Ken Gibson.
4.
Chancellor John Rambo.
4.
And Earl Houston.
4.
All approve the minutes as it was motioned.
Okay, passes.
Passes.
Okay, and now recognize the director for the director's report.
Thank you. If I could take a quick step backwards, I don't think we motioned the agenda, passing it as the agenda for this meeting is. If anyone could motion and second it.
Ken Gibson, I will make a motion that we pass the minutes as amended.
This is a minutes. I missed that step. I apologize.
Right.
Excuse me, the agenda. We'll get it right at some point.
This is Chancellor Rambo moving that we adopt the agenda.
Perfect. Thank you. And I'll do a quick roll call as well. Britton Collins.
4.
Ken Gibson.
4.
John Rambo.
4.
Earl Houston.
4.
All approve the agenda and the minutes, and so we can proceed. I believe that everyone was emailed the information, and you hopefully have in front of you 2 documents that we're considering part of the director's report. On our iPads, we're on page 5. The first one is the new look of how we will be presenting the financial information to each board, council, and commission. that is breaking up the revenues and the expenses a little bit differently. This is for this fiscal year, so we have July, August, September, and October expenses and revenues for you to see. The good thing to this presentation is that cost backs are being allocated as efficiently and accurately as possible on a monthly basis instead of at the end of the fiscal year. So on occasion, it will put some programs to look like they've not made money to be self-sufficient at that point in time, depending on your renewal cycles. And that's possibly what will happen with court reporting since you all renew at the same time. But you can see here on the top section that for the end of October, we have total revenues of $13,500 received and expenses of $2,590. So we are still okay through October of $10,000. Need to expand the number, $940. And then this report at the bottom will give everyone some historical view as comparing year to year at that exact point in time that will also help us as we continue using it. Any questions from anyone?
This is Ken Gibson. I just have a question about some terms. The term cost back, what is a cost back?
That's a really good question. So the cost backs for us include administrative cost backs, the different positions that don't fall necessarily directly with each board or position or commission, but are part of Commerce and Insurance's regulatory board. So we have those expenses. We have field enforcement individuals for, in some cases, investigations for a complaint would fall in there. And so there's a distribution of different cost backs that, based on how they are used, are charged back to each program. So they may be very minimal to pretty high. A new cost back now is, if you look at that bottom line under expenses, the customer service area. So in early 2016, and Nicole might not have had a chance to update everyone about it, but it's a great change. We have what's called a customer service center, and we're all charged accordingly for it, but they pick up the phone calls for all of the regulatory boards. We moved into them picking this up on a gradual basis. They also take in all of the emails that come in, and the goal is to be very, to approach customer service as efficiently and as well as possible. In other words, to make sure that customer service is our first priority, and we do that by these people specializing in that. So each office still has team that handle the calls, but if any of you have had to call in, you very likely have gotten kind of this customer service approach to it. It's working real well. It took a little bit to get there, and so of course that's part of our cost back now. Each group is charged for that as well. But at this point, at least, we're doing really well with that. It's helping make sure that all calls are returned, and we have a great metric system to make sure that emails are responded to and nothing's lost within there.
Okay, thank you. And then one more term, Edison expenditures. What is an Edison expenditure?
So Edison is the system in which it's the database that the state uses to pay us for payroll, to reimburse your per diems, to account for expenses. It has contracts. Everything is in Edison. It's the system that the state uses. So reimbursement from Edison's could be expenses for per diems, for example, travel expenses from you all. Anything that is coming from there from an expense. That's the name of the system.
Thank you.
Absolutely. The next page, and we may have questions on it as well, if you look and if you've got them through email, this is the actual expenditures, the closing of those 4 years. So if you look at fiscal year 15-16, which is the first time that the program is part of Commerce and Insurance, you'll see all of the expenses there, ending in the total net for the fiscal year of $57,098. And so that would have concluded 15-16. And then, of course, we have the carryover from the reserve that was brought before we had the program. So it's ending in a surplus of $140,776. This particular report we will update always just once a year. And this is where the other programs that have been part of Commerce and Insurance would, at the end, just see this huge cost back. And so I really like the fact that we can show it to you on a monthly basis. And so you won't see this one again until we close the books for the next session. But it's a full view for you to have. I wanted to point out that the court reporters, as those of you that renewed in June probably noticed, the database that we have for all of our tracking of complaints and licensing had a huge upgrade from a DOS-based computer system to the Current Times web browser. It impacted every board, and it has been a huge success. But with that, the court reporters didn't come into our hands until after we rolled. So we've still had your licenses in a more traditional paper world, if you will. We will be converting that over fairly soon. We've gotten an estimate from the vendor to move all that over. So that's a bit of good news. So for those of you that are needing a duplicate of a license or whatever, it will flow smoother, and hopefully in the near future you'll be able to renew online and take advantage of some of those other things. And that is all that I have. Any other questions? Wonderful. This is real easy. I'm going to go ahead and turn it over to legal. And at the end, again, anything that you have a question about, we can definitely cover. I think I've got one other report regarding licensure that might be at the end, and we can cover it with other questions before we conclude.
Ashley, you want to do the legal report?
Sure will. Good morning, everybody. We'll just go right through the legal report. I'll start. I believe you all received the legal report prior to today, so I'm just going to read the case number and then take any questions before I read my recommendation. The case number, for number one, is 201601. Were there any questions about my summary before I read the recommendation?
Not for me, it was clear.
Hearing no questions, I recommend that we authorize a formal hearing and send a consent order with the civil penalty in the amount of $500 for violation of Tennessee Comprehensive Rules and Regulations 0455-01-04-.01, subpart 1B and C. If the board has any questions or edits to that recommendation, I'll be happy to answer any questions.
This is Ken Gibson. Is the recommendation that a consent order with a civil penalty of $500 be sent before the hearing? In other words, why are we sending a fine or levying a fine of $500 before there's an adjudication of guilt in their formal hearing?
Right. Okay. So the consent order will be a matter of settlement. If the board finds that this activity does rise to the level of a violation, we will propose that they pay a penalty for that violation. If they do, the case will settle. If they choose to not settle it, at that point we could go forward with a formal hearing, and I would not have to bring the case back to the board to get that authorization to proceed to a formal hearing. Does that answer your question, Mr. Gibson?
The fine won't be levied until after there's a formal hearing. Is that correct?
No, sir. No, sir. I'm sorry. Go ahead.
Oh, this is Earl. Mr. Gibson, I think what she is trying to explain is that the $500 fine is going to be a consideration of settlement. So she's going to.
Gotcha.
At this point, she has determined that there was a violation, and that for that violation, there should be a penalty of $500 or a fine of $500.
Okay.
She's going to offer that as a settlement to
Gotcha.
This reporter by way of consent order. If they agree, then they will sign the consent order and pay the fine, and that's the end of the matter. If they do not agree, then they have a right to a hearing, at which point we'll have a hearing, and then the determination will be made at that point.
Okay, thank you. I'm sorry for my confusion. Appreciate it.
You're welcome.
That's okay. Are there any other questions?
This is Chancellor Rambo. I have a question. How did you arrive at $500 for your recommendation for a consent fine?
So for this particular fine, I looked at the two different subparts that I cited, and the $250 per violation for each part. That is a number that I know, looking at the facts of the case, it may seem egregious, and I had that thought as late as this morning. So I'm willing to adjust that if the board sees fit, but that is where I initially thought $250 for the violation of Part B, and then $250 for the violation of Part C.
Thank you for
Sir.
We've had a little bit of confusion, and I think part of it was when we were doing the rulemaking hearing last year, there have been some adjustments in what statutorily were authorized to assess as far as civil penalties. At one point it was 500, and then at some point it maybe went to 1,000. Do you recall where we're at now?
As far as the rule change, I think we settled on that the current law, if you give me just a second, I'll look it up. Okay, so the current law says that the fine shall not exceed $500.
For violation.
Yes. Reading it more closely, it just appears that the $500 is for unlicensed activity. I don't think that there is a statute right now that puts a limit on other violations for licensees. Other than what's in the current rules, I'm sorry.
Anyone care to make a motion?
What suggest the motion, please?
Well, I guess there are an infinite number of options. I guess the issue before us now is whether to accept council's recommendation as stated in the legal report, or to somehow modify it, whether it be
A change of
a lesser amount, more of an amount. Say we don't want a traffic consent order at all, and we just want to move forward with a disciplinary hearing. Anything you?
I would like to make a motion. This is Chancellor Rambo. I move that we authorize the formal consent order with a civil penalty in the amount of $500 for violations of Tennessee Rules 0455-01-04-.011B and C.
This is Earl. I'll second the motion.
Let the director call the roll.
Thank you. Mr. Collins?
For.
Mr. Gibson?
4.
Chancellor Rambo?
4.
And Mr. Houston?
4.
All in agreement to go with the recommendation as stated. Thank you.
And we do have one other case to represent. That number is 2012-05. I'll give the board some time to look over that and pose any questions you may have. This case was actually prepared by disciplinary counsel Shalina Brown, who is here if you all have questions for her.
This is Ken Gibson. I have no questions.
I don't have any questions so much as I have concerns. I understand the recommendation. The concern that I have is, well, it's twofold. One is that if we simply close the matter, there's nothing at that point that's going to prevent necessarily this reporter from seeking to move back into the state, reinstate their license, and go on with business as usual, which is problematic for me. Under the circumstances as outlined, accepting this statement of facts to be true, I'm troubled that that reporter would be able to do that. Secondarily, with the recommendation that it be closed with a voluntary dismissal without prejudice, the idea being that it could be reopened, I'll look to legal counsel for guidance on this, but our rules, and I think the statute actually says that complaints have to be filed within 60 or 90 days after the incident of which the complaint is aimed. How does that come into play if we voluntarily dismiss this and then a year from now it comes back up? Is there a conflict between that timing and the 60 or 90 days that's in the statute?
Just speaking to the closing of the case, and then I'll turn it over to Ms. Brown. Speaking to the closing of the case, typically for Commerce and Insurance, if we close a case, we would always flag it if there's a licensee. So at any point that this reporter decides to reinstate or renew their license, this complaint would be reopened in that regard. My initial response to the 90-day time limit that you mentioned, Mr. Collins, I would say that the complaint was submitted within 90 days, and if we reopen it, it's not necessarily opening a new complaint, but rather continuing with the prior complaint. But I'll let Ms. Brown expound on that.
Yes, sir. This is Shalina Brown. I am the disciplinary counsel. As you know, that there is a new system in place, and I will be assisting with court reporter cases. In this case, because we filed the notice of hearing and charges, and if we dismiss this and we are able to find her, we've just have had such a hard time finding her that we would just keep this open in perpetuity, which we could if you would like, but it really would make no sense. But we could easily just file another notice of hearing and charges in this matter once a complaint was reopened. But we followed the rules in terms of opening the complaint with the board.
And just for clarity of the record, I'll go ahead and read Ms. Brown's recommendation into the record. Since we are unable to locate the respondent to serve formal charges, and this matter has been pending since 2014, the respondent is no longer a licensed court reporter by this board, and the original infraction by the respondent occurred in 2012. It is recommended that this matter be closed and a voluntary dismissal without prejudice be filed in the docket.
This is Chancellor Rambo. I'd like to move that we adopt the recommendation, and I would like to address the motion.
Is there a second?
Ken Gibson, I second.
Director, call for roll, please.
Thank you. Mr. Collins?
4.
Mr. Gibson?
4.
Chancellor Rambo?
4.
And Mr. Houston?
4.
All in favor of going with the recommendation as stated. Thank you.
I think from the legal side, the only other thing I did want to mention to the board just briefly is that the rules that were filed with the Secretary of State are due to be effective on February 15th, 2017.
February 15th, you said?
Yes, sir.
Would it be possible, once those go into effect, could y'all just go ahead and email a set of the new rules out to all the board members?
We definitely can. The other thing, just in case the board hasn't had a chance to be walked through, there's an email notification system on our website. So if you go to the core of tn.gov and under businesses as well as government, you'll find the regulatory boards. You get to the court reporter section, and in any of the boards, under the contact information, there's a Get Notified button. If you will make sure to sign yourselves up to get notified for this board and any other program you're interested in. That way, when any legislation goes through, rules, if we have to do a blast of some sort that I can't imagine occurring for this profession, but sometimes we do, we use that system to notify anybody that's involved. So I do encourage you to, because then you'll get the link to the Secretary of State site, you'll be updated immediately, as opposed to waiting for emails to come directly from us. So definitely encourage you to do that. That way we never miss you. And if you see other professions you're interested in, we've got some professions with 3,000 to 5,000 people signed up to get them, so it's out there for the public as well. So we definitely will do that.
Okay, thank you.
The only other thing I think that Shalina kind of touched on that I don't know if you wanted to update, would you like to? Okay. So the legal department or the legal division has gone through some changes in trying to be efficient with complaints, handle them better, and kind of divide the loads, if you will. Some of the programs that have many complaints are more impacted by this, but we've done it with all the regulatory boards. So you are going to continue having Ashley here as our board attorney. She will be handling board business, attending the meeting, guiding us, licensees that call with questions, rulemaking information. That is how the board attorney's workload is handled. And then each program has a different litigating attorney. And in this case, Shalina will be handling these. And that means that when a complaint is open from the very beginning until the end, you have one person looking at it, as opposed to our previous process was if the settlement agreement wasn't accepted, at that point, it moved to litigation, and that attorney had a learning curve of taking it on. So that's a change across the board that I just want to make sure that everybody understood, and if you have any questions, we'll be happy to address them as well.
And this is Ashley Thomas. Just to add on to that, yes, Ms. Shalina Brown will be a disciplinary counsel, but the board will actually have 2 disciplinary counsels. Also, Ms. Lindsay Shepard will also be disciplinary counsel for this board.
Okay. Let's see. Now we need to adopt our 2017 meeting dates.
I think that everyone has received the copy of the dates. We've scheduled the meetings for March 24th of 2017 and September 22nd. That's the 2 meetings that we have to have by statute. So a few weeks before each of those dates, either myself or Cody, we will make sure to reach out and be assured that we have quorum. If for some reason we wouldn't, we would have to set a different date. But the hope is that we will. And so, yeah, we will need a motion to accept those unless there's any problems with those dates that we foresee already in advance and would need to change them.
This is Ken Gibson. I make a motion to adopt those dates.
This is Chancellor Rambo seconding the motion.
I'm looking Director call for a roll, please.
Thank you. Mr. Collins?
4.
Mr. Gibson?
4.
Chancellor Rambo?
4.
And Mr. Houston?
4.
All in favor of adopting the 2017 dates as previously mentioned. They are posted on the website, so we will proceed with those. And I have nothing further at this point. I had a report with some licensure information. I'll make sure to present that the next time and email it to everyone just to give you a feel for what our numbers are with renewed court reporters and that kind of thing. Everything looked in line as to what you're used to. I just figure periodically we'll update those things as well, so you're always kept abreast of what's going on with the industry, but I have nothing else otherwise.
Any of the board members have any business to address with the board?
I would just like to ask, this is Ken Gibson, the formal hearing that we spoke of earlier, will that be held on March 24th, or is that not set in stone?
At this time, that's not set in stone. So from here, I will prepare that consent order and send it to the respondent. If that person responds to it and pays the civil penalty, there will be no formal hearing. That is what will happen if there is not an acceptance of that consent order.
Thank you.
Yes, sir.
I have one thing. And Earl will know what I'm talking about here. We've, over the last several years, have battled back and forth. Under the statutes, it's suggested strongly, it seems, that if we have surplus funds, we're supposed to set up some sort of program for indigent court reporting to allow indigent and pro se litigants to retain the services of court reporters. We've discussed ad nauseum over the years and never been able to develop any sort of program, even though we always seem to be in pretty good financial straits. I think our costs have gone up since we've shifted from the Administrative Office of Courts over to the Department of Commerce and Insurance. So I don't know if doing something remains feasible. I mean, you look at our balance sheet now and it looks great. we've got whatever $120,000, but we're also a board that really only gets revenue every other year. So we have to be cognizant of that. But the legislature has told us that we need to do that if we have extra money. We've never done that. We need to do what the legislature says if we've got that money. So I do think that we need to address that, determine whether that's something that we should be doing, and if so, we need to develop and implement a program somehow to be able to do that. So I think that's something we need to address maybe over the next couple of meetings.
Mr. Collins, this is Ken Gibson. If there's a surplus, what is the possibility? I'm all for helping indigents and all that, but what is the possibility of reducing the burden on court reporters by reducing their fees? Is that a possibility?
We set the fees by regulation, so this board decides what those fees are. So yes, that is also a possibility. That would be the counter. One or the other needs to happen to the extent that we're bringing in more money than we're ever going to feasibly use. And if we assume that we're going to have a relatively stable number of reporters, I think it's 500 or 600 that we've got now, and if we anticipate that that's going to remain stable, it's pretty easy for us to forecast what our revenue is going to be. The expenses are a little bit different, but I think they're probably fairly easy to forecast. So that's certainly a possibility too, but we don't just need to be hoarding money that's coming directly out of the court reporters' pockets. It needs to either go back into it or be used as the legislature has told us to.
Correct. I just think that I think there's room for balance. We can do both, help indigents and return a little money to the court reporter.
I don't know whether we can give it back, but we could certainly reduce fees in the future if we realize that maybe we're taking too much.
Thank you. I just would like for that to be on the table.
Absolutely. And this is Roxana. So absolutely both of those are options, I think. So let me ask, as far as creating this program for the indigent assistance for court reporting, has any plan been drafted? Do we have anything to start from?
No. Ken Mansfield and I were supposed to have done that probably about 2 years ago. And then, other things came up before the board, then we had the transition over to here, so that just kind of got lost in the fray of all of that. There are other states, several other states, I think, that have programs. I couldn't tell you off the top of my head which ones they are. Ken, you may know more about that since you're the only reporter present at this meeting. But there are other states that have programs like that. I think there are different models, perhaps, but...
yeah, I'm not aware of them. I'm sorry.
Yeah.
This is Chancellor Rambo, if I may address the issue. It seems to me an odd thing for the legislature to ask us to set up a program for indigent court reporters. Now, I believe in access to justice. You can't afford an attorney to get your divorce, or you have criminal charges pending against you and your liberties are at stake. But this is a profession that not everyone is entitled to do. There's no indigency program to join other professions. I feel like maybe we have the concept, just because court reporters are related to the justice system, that we have to make it accessible. I would tend to favor reducing fees for the court reporters instead of trying to come up with some type of program for people who are indigent. The whole definition of indigent court reporter does not make a whole lot of sense to me.
I think there may be a little bit of confusion. And this may be my fault. I probably shouldn't have couched it in those terms. The statute suggests that we should set up a program that allows indigent parties in litigation to retain the services of court reporters. Not necessarily the court reporters doing pro bono work, but somehow, essentially, the board providing a subsidy to indigent parties so that they can retain court reporters, whether it be the work any number of ways, but the to allow those people to access the services of court reporters, not to allow folks who court reporters.
That makes a whole lot more sense.
Sorry.
And let me say this. I try a lot of termination of parental right cases, and you're entitled to have an attorney appointed if you're indigent, but it is very, very difficult to find funds to pay for a court reporter because if you look at the opinions that come out of the Court of Appeals and the Supreme Court, a good chunk of those relate to the termination of parental rights, and you have to have a transcript. And I have been there where the lawyers are paying for it out of their own pocket, and they're not being paid very much at all to do the case, period. And that seems like an area that we could explore on maybe helping to cover some of the court reporter costs on termination of parental rights cases.
Well, since we've got everyone, or at least a good quorum at the table, if this is a good time to discuss how to proceed, do we need to, give an assignment, if you will, or some type of follow-up so that we do some research on what other states are doing, what looks feasible, and do present a plan at the next meeting? That would give us time. The board office can definitely help implement. I mean, we have these type of grant programs or surpluses being used for exactly these kind of things, and much of it is in the statute. Sometimes it isn't. So definitely there's no reason to hold a huge surplus that you're not going to need. I think we would make we would use fiscal folks. My background is finance as well. We would make sure to have enough cushion that would not be, and however we set it up, there'd be a reserve of what we always need for the next 2 years ahead. Once that's covered, we can deal with, what is the program, how should it look, how would one qualify, all that would be then at your discretion and for you to decide how to proceed.
This is Chancellor Rambo again. I think it sounds like the board would like this to be on the agenda in the future, and it would be helpful to see what other states are doing as far as research and investigation, and secondly, to talk to the AOC, various other agencies to determine where the need is, and if there's some way that we can help plug that need or fit into the overall scheme of things. So, if there's some pot of money out there that would cover these things that we don't know about, then we don't need to be devoting our resources to a need that's already met.
We'll definitely add it to the agenda. If between there anything new comes up, any of you have information like you mentioned, Chancellor, from the Administrative Office of the Court to find out what else is out there, we would love to receive it. We will put it together. I will have some conversations with the boards that are doing these type of programs to give you some options as well. I think that piece is going to be the easy piece. I think the hard one is going to be debating how you want that to run, and I'll also come up with that number of what the reserve should be. So we're looking at, are we starting with 30,000, something realistic, and we have a game plan, and then we can proceed also to look at the next round of rulemaking, reducing the fee if that's what everyone decides as well. If there's nothing else, I think we can motion to adjourn, but if not.
Anybody have anything else? Okay, is there a motion to adjourn the meeting?
So moved, Chancellor Rambo.
Second, Ken Gibson.
And Director, call the roll.
Thank you. Mr. Collins?
4.
Mr. Gibson?
4.
Chancellor Rambo?
4.
Mr. Houston?
4.
All in favor of adjourning the meeting, thank you very much. It is 9:45.
We're adjourned. Thank you.
Thank you.
Everybody have a happy holiday.
Thank you.
Thank you.
Same to you. Thank you.